There are plenty of myths that revolve around the Second Amendment. For example, it's only meant for the militia or for hunting, or some weapons are just too dangerous, or only a few. When we read the Constitution, along with just a tiny bit of research into the Bill of Rights, these myths should evaporate like the morning mist. In the case of Bianchi v. Brown, it appears the Fourth Circuit believes these myths. However, some unorthodox procedures may show the court manipulated the process to get the outcome they desired. So we'll take a look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation Be Free. I'm glad you could join me today. Again, Second Amendment issues tend to get a lot of attention here on the Constitution Study, but there's actually more to this than just the Second Amendment. I've covered a lot of these topics before. You can find them on the website, constitutionstudy.com. I'll talk more about the website and some other things at the end of the episode, but for now, let's take a look at this Bianchi case. Maryland, like some other states, have laws known as assault weapons ban. First, we have to define what Maryland calls an assault weapon. The statute defines assault weapon as an assault long gun, an assault pistol, or a copycat weapon. The term assault long gun, in turn, encompasses more than 45 enumerated long guns or their copies, regardless of which company produced and manufactured the firearm. These proscribed guns include an assortment of military-style rifles and shotguns capable of semi-automatic fire, such as the AK-47. Almost all models of the AR-15, the Spaz-12, and the Barrett 50 caliber sniper rifle. The term assault pistol encompasses more than 15 enumerated firearms and their copies. These include the Tech-9 and semi-automatic variants of the MAC-10, MP5K, Uzi, and other military-style submachine guns. Maryland defines many different rifles, shotguns, and pistols as assault weapons. Now, many of these weapons are actually semi-automatic weapons as opposed to the full automatic many people think of as assault or military-style weapons. Maryland also defines a copycat weapon. Copycat weapon is defined as a firearm that is not an assault long gun or assault pistol, yet is covered by at least one of the following 6 categories. A semi-automatic centerfire rifle that can accept a detachable magazine and has any 2 of the following: a folding stock, a grenade launcher or flare launcher, or a flash suppressor. A semi-automatic centerfire rifle that has a fixed magazine with a capacity to accept more than 10 rounds. A semi-automatic centerfire rifle that has an overall length of less than 29 inches. A semi-automatic pistol with a fixed magazine that can accept more than 10 rounds. A semi-automatic shotgun that has a folding stock, or a shotgun with a revolving cylinder. What I find interesting are the banned features that have nothing to do with the lethality of the weapon. For example, how does a folding stock or a flash suppressor make the weapon more lethal? The answer is it doesn't. Maryland law prohibits any person in the state from selling, purchasing, receiving, transporting, transferring, or possessing an assault weapon, subject to limited exceptions. That's from the Maryland Criminal Code. A violator of these statutes faces up to 3 years imprisonment. Maryland law enforcement officers are authorized to seize and dispose of weapons sold, purchased, received, transported, transferred, or possessed in violation of the law. There are several constitutional issues with this Maryland law, not just the Second Amendment. Chief among them is the confiscation of so-called assault weapons. For example, is it reasonable for law enforcement to seize property that was legally purchased? It's one thing to seize an item that was purchased or even transported in violation of the law. But what about the weapons that were purchased, received, or transported before this law went into effect? This law potentially violates the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." It also violates the 14th Amendment, which states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Now, those who challenged the law did not claim it was a violation of the Fourth or 14th Amendments, but of the Second. Appellants are three Maryland residents who allege that they are legally eligible to possess and acquire firearms, three nonprofit gun rights organizations to which the residents belong, and a licensed firearm dealer based in Maryland. On November 13, 2020, appellants filed a complaint under 42 U.S.C. Section 1983 in the U.S. District Court for the District of Maryland against the then Attorney General of Maryland and other state law enforcement officials. Appellants contend that these officials' enforcement of Maryland's assault weapons regulation was unconstitutional under the Second Amendment's right to keep and bear arms as applied to the states through the 14th Amendment. They sought a declaratory judgment that the regulation prevented them from exercising their right to keep and bear arms, as well as an injunction to prohibit appellees from enforcing the statute. Again, we have the lie that the Bill of Rights did not apply to the states until the 14th Amendment, which is all based on a claim written by Chief Justice Marshall without any evidence at all. I go into more detail in the article The Bill of Rights and the States, which you can find on the website. The question remains, though, does this Maryland law violate the Second Amendment? In their complaint, however, appellants acknowledge that the result they seek is contrary to Colby v. Hogan. In Colby, we upheld against a constitutional challenge the very same Maryland statute at issue here insofar as it applied to the assault long guns and those copycat weapons that are rifles and shotguns. Our en banc opinion rested on two distinct grounds. We first concluded that the assault weapons at issue were not constitutionally protected arms. We then found that, even assuming the Second Amendment reached such weapons, the Maryland regulations survived intermediate scrutiny. Bianchi and company agreed that what they were asking the court to do was contrary to their previous opinion in Colby v. Hogan. Now, between the court's decision in Colby and this case, however, the Supreme Court had decided the New York State Rifle and Pistol Association v. Bruin. On June 23, 2022, before ruling on the cert petition, the Supreme Court decided New York State Rifle and Pistol Association v. Bruin. In Bruin, the court disavowed as one step too many the two-step framework that our court used in Colby and that other federal circuit courts had nearly universally employed to assess Second Amendment claims in the wake of District of Columbia v. Heller. Although step one of the predominant framework, which was rooted in the Second Amendment's text as informed by history, was broadly consistent with Heller, the court emphasized that the means-end scrutiny at the second step was improper because the Second Amendment codified a pre-existing right. Courts were not to engage in interest balancing to determine whether a challenge regulation was constitutionally permissible. Instead, we were tasked with discerning the historical scope of the right and parsing whether the challenge regulation was consistent with it. The Supreme Court said the Fourth Circuit got it wrong in how they analyzed the case. Now the court had to look at whether the law fits within the constitutional text and history. A week after Bruin was decided, the Supreme Court granted appellants' petition for writ of certiorari, vacated the judgment, and remanded the case for further consideration in light of Bruin. We ordered the parties to provide supplemental briefing, and a panel of this court heard oral arguments on December 6, 2022. Before an opinion issued, however, our court voted to rehear the case en banc. We received additional supplemental briefings from the parties and heard oral arguments as a full court on March 20, 2024. Now, with the benefit of Bruin, we can proceed to decide this case. The court GVR'd, or granted certiorari, vacated the judgment and remanded it, or granted, vacated, and remanded, and sent the case back to the Fourth Circuit to consider it based on the Supreme Court's opinion. This is where some shenanigans came in. Let's start with the explanation of what happened from a footnote on page 87 of the decision. This unorthodox procedural posture bears some explanation. After hearing the case in December 2022, the initial panel majority reached a decision and promptly circulated a draft opinion. Yet for more than a year, no dissent was circulated. The panel thus held the proposed opinion in accordance with our custom that majority and dissenting opinions be published together. A year later, a different panel heard arguments in United States v. Price, which also involved interpreting and applying Bruin. The Price panel quickly circulated a unanimous opinion that reached a conclusion at odds with the Bianchi majority's year-old proposed opinion. Facing two compelling proposed published opinions, the court declined to let the earlier circulated opinion control. Rather, in January 2024, we invoked the once extraordinary mechanism of initial en banc review. I hope that we will not find ourselves in this posture again soon. What's interesting is they looked at United States v. Gibbs, where One of the voting members suggested that majority opinions may be issued without awaiting dissent opinions to prohibit those dissenting opinions from exercising a pocket veto or to deny and delay fairness and justice. So after hearing the case in December, the court sat on it for more than a year. Why was no dissent circulated? Was one written but not distributed? Did one of the panel vote against the decision but never write a dissent? I don't know. However, it's apparent that another panel had a unanimous decision different than the one the Bianchi panel had come to. To make things worse, the full court decided to review the case even though the reviewing panel had not published its decision. Why did the court make this extraordinary move? Could it be that, as the court in United States v. Gibbs warned, that the dissent exercised a pocket veto? Did the dissent in Bianchi delay justice to get the outcome they wanted? With that question in mind, let's go back to the facts of the case. The Second Amendment instructs a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This single sentence provides us with a lofty command, but little concrete guidance. In the past 2 decades, the Supreme Court has stepped in to provide this guidance, offering a methodological framework by which to structure our inquiry. Now, here I completely disagree with the court. The Second Amendment gives concrete guidance. The right of the people to keep and bear arms shall not be infringed. That is a positive declarative statement. It doesn't get much more concrete than that. Anything that infringes on the right of the people to keep and bear arms is prohibited. Of course, I'm pretty sure the court wants some wiggle room in order to get the outcome they want. Yes, the Supreme Court has provided guidance, but that guidance seems to contradict what the Constitution actually says. This was a question we earlier faced as an en banc court in Colby. Our primary holding in that case was that the assault weapons regulated by the statute were not within the scope of the Second Amendment. Specifically, we resolved the case by finding that the covered weapons were like M16 rifles, i.e., weapons that were most useful in military service, and thus outside the ambit of the Second Amendment. It was only after we affirmed the district court's award of summary judgment in favor of the state on those grounds that we turned to finding in the alternative that assault weapons regulations survived intermediate scrutiny. This is where the court goes completely off the rails. First of all, only one of the covered weapons were anything like an M16. Second, how does the fact that a weapon is like another remove it from Second Amendment coverage? Of course, we still have this scope of the Second Amendment question. Having elucidated our understanding of the Second Amendment's text in its historical context, we turn to the Maryland regulation under challenge in this case. Our analysis confirms that the covered weapons are not within the ambit of the right to keep and bear arms as codified within the plain text of the Second Amendment. While the court may have elucidated their understanding of the Second Amendment, their understanding is not based in the law. The court provides no evidence that when the drafters or ratifiers of the Second Amendment said arms, they actually meant, well, arms that are not too scary or too dangerous. In short, their analysis is not based on the language of the Second Amendment, but on their desire to get a specific outcome. We recognize, however, that the parties thoroughly briefed the issue of whether the Second Amendment protects a citizen's ability to purchase and possess an AR-15, which appellants refer to as the paradigmatic semi-automatic rifle targeted by assault weapons ban. This is also the question we primarily considered at our en banc oral argument. Because it has been fully briefed and considered after a remand from the Supreme Court, we find the question of whether the AR-15 is within the ambit of the Second Amendment appropriate to address here. Not to address it would be to bypass the very heart of the dispute in this proceedings. Now, since the AR-15 is so often the target of these assault weapons bans, the court takes the time to look specifically at that weapon. Sadly, the court again gets their facts wrong. The civilian versions of the AR-15 have not strayed far from their rifle's military origin. The AR-15 is not derived from military weapons. It's actually the other way around. From an article on the history of the AR-15, first developed in the 1950s for civilian use, the AR-15 rifle was named after its manufacturer, Armalite. The letters AR do not stand for assault rifle or automatic rifle. Armalite sold the rifle's design to another firearm manufacturer, Colt, in 1959. 4 years later, the U.S. military selected Colt to manufacture a standard issue model of the AR-15, dubbed the M16, for soldiers in the Vietnam War. The AR-15 was originally designed for civilian use. Years later, after purchasing the design from Armalite, the Colt company developed a military version known as the M16. Colt later built the civilian semi-automatic version with M16 stock, so they would look the same. The court goes on to show its ignorance regarding firearms and ammunition. The AR-15 continues to use the same internal piston firing system and the same ammunition as the M16. Its bullets leave the muzzle at a similar velocity of around 3,000 feet per second, have a similar effective area target range of up to 875 yards, and deliver a similar amount of kinetic energy upon impact. The court starts with pointing out that the AR-15 and the M16 use the same firing system. That merely means that both weapons fire, extract the spent casing, load a new round, and return to battery the same way. Specifically, there is a spring inside a tube, known as a buffer tube, that stops the bolt when it's pushed back by the firing round and pushes the bolt back into battery or ready to fire. By the way, while the specifics may be different, this is pretty much how every semi-automatic weapon works. Either the recoil or gas from the fired round pushes a bolt or slide back into a spring, which then pushes it back into battery. The court also makes a scary point that both the AR-15 and the M16 have similar muzzle velocities. Of course, the court fails to mention that more than 36 rifle calibers have a muzzle velocity of 3,000 feet per minute or more. In fact, of those 36 calibers with at least a 3,000 foot per minute muzzle velocity, 2/3 are faster than the .223 or .556 used in the AR-15. In fact, the average deer rifle cartridge, like a .308 or a .30-06, has up to 50% more kinetic energy than the .223, and they're not considered assault weapons. Contemporary versions of the AR-15 and M16 have both incorporated additional combat functional features. These include a flash suppressor that conceals the shooter's position and facilitates night combat operations, and a pistol grip that enables fast reloading and accuracy during sustained fire. While I'm not an expert on combat functional features, I can tell you that a flash suppressor comes in very handy if you happen to need to use your AR-15 for home defense at night or in a darkened room. And personally, I cannot see why faster loading or accuracy would be a bad thing, whether it's for a shooting competition or defending yourself and your family. Most versions of the AR-15, like the M16, use detachable 20 or 30 round magazines that increase the weapon's effective rate of fire and are most useful in prolonged firefights with enemy combatants. Both weapons are also compatible with up to 100 round magazines. Other combat function features include that the AR-15 and M16 include a threaded barrel for affixing of a flash suppressor, recoil compensator, or silencer, a barrel shroud to protect the shooter's hands from excessive heat during sustained fire, and a rail integration system for the mounting of sights, scopes, slings, flashlights, lasers, foregrips, bipods, bayonets, and under-barrel grenade launchers or shotguns. In short, the court appears to not like the AR-15 because it's a very flexible and capable platform. Lost on the court is the fact that there are plenty of legitimate reasons to sustain fire. Shooting competitions or having to defend yourself against a gang of criminals attempting to enter your house are just a few. The firepower of the AR-15 and M16 is a key component of their phenomenal lethality. Built to generate maximum wound effect and to pierce helmets and body armor, AR-15 bullets discharge at around 3 times the velocity of a typical handgun. These higher velocity rounds hit fast and penetrate deep into the body, creating severe damage. The idea of the AR-15 having a phenomenal lethality, again, shows the ignorance of the court. The World War II workhorse rifle, the M1, used a .30-06 round with similar muzzle velocities and up to 50% more kinetic energy than the .223 used by the AR-15. Add to that the fact that most rifle rounds have 3 times or more the muzzle velocity of a typical handgun, and it becomes quite clear that the court knows very little about firearms or what makes them dangerous. All the language about the lethality of the AR-15 is nothing but scare tactics and displays the utter ignorance of those trying to justify their infringement on your rights. Now, based on all this, how did the court find? The framers recognized they could not foresee all the dangers that novel weaponry would someday pose or the circumstances that would invoke the basic power of government to protect the governed. Maryland is a testament to their prescience, though other states with their characteristics and other approaches to this problem may be as well. we have before us nothing more or less than a challenge to one state's regulation of assault weapons. Following Heller and Bruin, we hold that the Maryland statute is plainly a constitutional enactment. The Second Amendment was not drafted to limit the powers of the people so government could protect them. The Second Amendment was drafted to ensure the American people could defend themselves, including against a government that went beyond its limited and enumerated powers. That's why the Second Amendment protects the right to keep and bear arms, which Webster's 1828 dictionary defines as weapons of offense or armor for defense and protection of the body. Any arm, any weapon of offense or armor for defense is protected by the Second Amendment. The members of this court violated their oaths of office, first, by placing the decisions of the Supreme Court above the Constitution, the supreme law of the land, and second, by substituting their own preferences to the actual language of the law. Are their weapons too dangerous for the people to use? If they are, then they are too dangerous for people in government to use as well. In fact, the very aspects of the AR-15 and the other arms listed as assault weapons are exactly why our right to own and carry them are protected by the Second Amendment. George Washington said, "The very atmosphere of firearms anywhere and everywhere restrains evil interference. They deserve a place of honor with all that's good." The purpose of the Second Amendment is not to protect hunting or shooting sports, but to ensure that the people have the tools necessary to restrain evil interference in their lives. The advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached, and by which the militia officers are appointed, forms a barrier against the enterprises of ambition more insurmountable than any which a simple government of any form can admit of. Notwithstanding the military establishments of the several kingdoms of Europe, which are carried as far as the public resources will bear, the governments are afraid to trust the people with arms. Those are the words of James Madison. The very fact that the American people are armed and can form militias attached to their states is a barrier to the enterprises of an ambitious government, even if the states and the people haven't used them lately. These are a few of the quotes from our founding fathers about our right to keep and bear arms, but I think they are best summarized by Noah Webster. Before a standing army can rule, the people must be disarmed, as they are in almost every kingdom of Europe. The supreme power of America cannot enforce unjust laws by the sword because the whole body of the people are armed and constitute a force superior to any bands of regular troops that can be, on any pretense, raised in the United States. A military force at the command of Congress can execute no laws, but such as the people perceive to be just and constitutional, for they will possess the power and jealously will instantly inspire the inclination to resist the execution of a law which appears to them unjust and oppressive. This court got it wrong for many reasons. They made outrageous and erroneous claims about the weapons in question. They attempted to scare people into agreeing with their decision, and apparently denied the appellants justice by delaying the publication of their decision until after another panel gave them the answer they wanted. Worst of all, this court completely ignored the law and made one up for themselves, which is definitely an act of bad behavior. Because of their malfeasance, people in Maryland would be denied their rights protected by the Constitution. Some may even be arrested, jailed, and forever denied their rights as convicted felons, in large part because this court sought an outcome rather than applying the law. I only wish the members of the court could feel the shame they so richly deserve for this decision. This was an activist court. It's plain and simple. They ignored the language of the Second Amendment and made it up for themselves. They simply declared these weapons are not covered by the Second Amendment. Why? What proof, what evidence do you have that the people who drafted the Second Amendment would think that? That the people who ratified the Second Amendment would think that? None. None. This is a criminal court. Bad behavior, which means they no longer should serve on the court. Remember Article 3. Judges of the Supreme and Inferior Courts serve during their good behavior. This is bad behavior. It's bad behavior on many levels. And sadly, the people of Maryland are going to have to deal with this, not only because the court screwed up, but because the state refuses to protect their rights. But then again, that's because the people in Maryland hire these representatives to infringe on their rights. So maybe they can do something there. That's why I say it's important to read and study the Constitution of this country, like John Jay said, so you know when your rights are violated and be better prepared to defend and assert them. In looking at this case, I saw another example of a decent argument being made, but I don't think it was fully prepared to defend and assert the rights of those of Bianchi and the rest of them, because they didn't get to the fundamental question. The Constitution, the supreme law of the land, supersedes everything else, and it says the right of the people to keep and bear arms shall not be infringed. The Constitution does not delegate to the United States nor to its courts to simply rewrite the Constitution the way they want, to put in qualifiers that are not in the language. Only the states have the authority to amend the Constitution, not the courts. That's why this case is so evil. Of course, it's not the first, and I doubt it's going to be the last. That's why we pay attention to these cases here at the Constitution Study. Now, I hope you like the stuff that we're doing here. Head over to the website, constitutionstudy.com. You can find this article and others with it. You can find the videos. I have mailing lists for news updates and all sorts of stuff. There's great stuff there. You can even find links to the radio program and some of my radio episodes. Again, at constitutionstudy.com. I recently came to an agreement with another study guide called The Miracle of America. Now, as a Constitution Study listener, you can get one lesson from this guide absolutely free. Just go to constitutionstudy.com/1776 study guide. That's the numbers 1776 study guide. You'll get a free lesson on, the foundation of the country, the natural law, the religious foundations of our country. And if you like it, we can sign up and order the rest of the lessons. You get them all for just $17.76. Again, that's constitutionstudy.com/1776 study guide to get your free lesson. You can also support me with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They support the same things that we do. They support our promotion of our constitutional rights. And yes, they support the Constitution Study. Go to patriotmobile.com/constitution. Find a plan that works for you. Not only will you get great 3G and 4G coverage, great US-based customer support, and support of organizations like the Constitution Study that are out to protect your rights, but you get great cell phone service while you're at it. So support the blessings of liberty with your cell phone. Again, that's patriotmobile.com/constitution. And if you use the code Constitution at checkout, you'll even get free activation. I hope you learned something here today. I hope maybe eyes were open. I hope you'll share this information with friends and family and social media wherever you can. But most of all, I hope you'll come back and join us here next time for the Constitution Study.